The house sat on the corner lot like it always had, quiet and well-kept. Its white siding freshly washed, and its small front porch lined with potted plants that softened the sharp edges of suburban order. For nearly a decade, the home had been a place of routine and predictability, a refuge built on long workdays, careful budgeting, and the quiet satisfaction of ownership. Nothing about it invited attention, and that was exactly how the homeowner preferred it. That peace began to unravel on a humid Thursday afternoon, the kind where the air felt heavy and tempers across the neighborhood seemed unusually short. It started with a sound. A sharp crack echoed through the house, followed by a deep thud that rattled the windows. At first, it sounded like a fallen tree branch or a delivery gone wrong. But when the second impact came, louder than the first, it was unmistakable. Something heavy was hitting the side of the house. The homeowner stepped onto the porch just in time to see a large landscaping truck reversing aggressively across the lawn, its tires tearing through carefully maintained grass. Behind the wheel sat Karen, a familiar face in the neighborhood. Her jaw clenched, sunglasses perched firmly on her head despite the overcast sky. She didn't stop. The truck lurched backward again, and this time the rear bumper slammed into the corner of the house. Wood splintered, siding cracked, a section of gutter snapped free and clattered onto the ground. Several neighbors froze in their driveways, unsure whether to intervene or retreat. Karen jumped out of the truck, her movements fast and irritated, as if she were the one inconvenienced by the destruction unfolding around her. She began shouting immediately. She accused the homeowner of blocking HOA access. She claimed the lawn was part of a shared easement. She insisted the truck had every right to be there, and that any damage was unfortunate but necessary. None of that was true. The homeowner stood silently at the edge of the porch, phone already recording. There was no yelling, no confrontation. Every word Karen spoke was captured clearly, every careless admission preserved without interruption. When she realized she was being filmed, her voice rose, her accusations growing sharper, more personal. She threatened fines. She threatened legal action. She threatened to have the house declared non-compliant. Then she drove away. The damage was worse up close. The siding was crushed inward, exposing insulation. The corner trim had been split cleanly, and water now dripped steadily from the broken gutter, pooling along the foundation. The lawn looked like a construction site, deep tire ruts carving a crooked path from the street to the house. Within an hour, a contractor confirmed what was already obvious. Repairs would be extensive. The damage wasn't cosmetic. Structural elements had been compromised, and moisture intrusion posed a serious risk if left unaddressed. The estimate came in just under $20,000. That evening, the homeowner sent a formal incident report to the HOA management company, attaching photos, videos, and the contractor's assessment. The report was calm, factual, and detailed. It requested acknowledgement and information about insurance coverage. The response arrived the next morning. It was brief. The HOA denied responsibility. They claimed Karen had been acting independently. They stated there was no record of authorized work on the property. They suggested the homeowner pursue the matter civilly if dissatisfied. Karen, when contacted directly, laughed. She dismissed the damage as exaggerated. She claimed the house was already falling apart. She suggested the homeowner should be grateful the HOA was improving the area. She ended the conversation by saying lawyers were expensive and lawsuits never worked out the way people expected. The homeowner said nothing in return. Instead, a timeline was created. Every interaction was logged. Every email saved. Witness statements were collected from neighbors who had seen the incident unfold. Security camera footage from nearby homes was requested and obtained, clearly showing the truck reversing into the house not once, but twice. By Monday morning, a demand letter was sent. It outlined the damages, included the repair estimate, cited local property damage statutes, and set a firm deadline for response. The letter was sent certified mail to both Karen and the HOA. Neither responded. On Tuesday, Karen appeared at an HOA board meeting and recounted the incident in her own words. She described it as a misunderstanding. She accused the homeowner of provoking her. She implied the damage occurred before she arrived. What she didn't know was that the video had already been shared with the HOA's insurance liaison. By Wednesday, the insurer requested a formal statement. Karen declined. By Thursday, the HOA's legal counsel advised the board to distance itself publicly from her actions. Karen doubled down. She began telling neighbors that the homeowner was litigious and unstable. She warned others to avoid interaction. She attempted to preemptively control the narrative, but the evidence was too clear, too damning. On Friday morning, the homeowner filed suit. The filing was efficient and precise. It named Karen individually for negligence and property damage. It included video evidence, witness affidavits, and repair estimates. The court date was set for the following week. When Karen was served, her reaction was immediate. She stormed into the HOA office, demanding intervention. She accused the board of abandoning her. She insisted they cover her legal fees. She threatened resignation, retaliation, and public exposure. The board refused. For the first time, Karen stood alone. Over the weekend, contractors began temporary repairs to prevent further damage. Tarps were secured. Water was redirected. The house, though wounded, was stabilized. Neighbors stopped by quietly, offering support, food, and help with cleanup. The story had spread, and sympathy had shifted decisively. Karen, meanwhile, posted online. She shared vague complaints about harassment. She hinted at conspiracies. She framed herself as a victim of an overreaching homeowner trying to silence her service to the community. The posts were met with skepticism and, eventually, silence. Sunday night arrived heavy and still. The homeowner reviewed the case file one last time, organizing documents into clean folders, each labeled and indexed. There was no anger left, only focus. The goal was no longer compensation alone. It was accountability. Across town, Karen sat at her kitchen table surrounded by papers she barely understood. She had assumed authority would protect her, that confidence would substitute for caution. Now, the reality of a courtroom loomed closer than she had ever imagined. Neither slept well. Monday morning came faster than expected. And with it, the beginning of consequences Karen had never planned for. The courthouse stood downtown like a slab of gray certainty, indifferent to ego, excuses, or neighborhood politics. By the time Karen arrived, her confidence had thinned into something brittle. She wore a blazer meant to signal authority, but it hung awkwardly, the fabric stiff, the smile forced. She had told herself all week that small claims court was informal, that judges were lenient, that things like this usually ended in mediation and mutual dismissal. What she had not prepared for was how little any of that mattered once facts entered the room. The homeowner arrived early, calm and organized, carrying a single binder and a quiet resolve. There was no dramatics, no attempt to intimidate. Everything that mattered was already documented. Every step had been planned with the understanding that truth, when presented cleanly, rarely needed embellishment. When the case was called, Karen spoke first. She framed the incident as an accident. She claimed confusion over property boundaries. She suggested she had been under pressure from the HOA to complete landscaping work quickly, and that the homeowner's behavior had been antagonistic. She spoke confidently, but her words lacked structure, jumping from justification to accusation without anchoring to evidence. The judge listened without interruption. Then the homeowner's evidence was presented. Video footage played clearly on the courtroom monitor. The truck reversing. The impact. Karen exiting the vehicle, gesturing angrily, speaking loudly about HOA authority. The timestamps were visible. The angles indisputable. Witness statements corroborated the sequence of events. Contractor reports detailed the damage, linking it directly to vehicular impact. Karen's posture changed. She tried to interrupt, but the judge raised a hand. She attempted to explain, but each explanation contradicted something already on record. When asked why she had entered the property without permission, she cited HOA responsibility. When asked to produce documentation supporting that authority, she had none. The HOA was not present. That absence spoke louder than any testimony. The judge asked a simple question. Had Karen been authorized by the homeowner to operate a vehicle on the property? The answer was no. Another question followed. Had she exercised reasonable care while operating the vehicle? The video answered that before she could. The ruling was swift. Karen was found liable for property damage and negligence. She was ordered to pay the full cost of repairs, court fees, and an additional penalty for reckless conduct. The judgment was not symbolic. It was enforceable. Karen stood frozen as the numbers were read aloud. The homeowner nodded once, thanked the court, and left. News traveled quickly. By that afternoon, neighbors were talking openly. The HOA issued a brief statement distancing itself from Karen's actions and affirming respect for private property. The board scheduled a special meeting to discuss policy changes regarding contractor access and member conduct. Karen resigned the next day. Her departure was quiet, announced in a single-line email citing personal reasons. There were no speeches, no farewells. Her authority evaporated as quickly as it had been abused. Repairs began in earnest. Siding was replaced. Structural reinforcements were installed. The lawn was restored carefully, inch by inch. What had been damaged was not just fixed, but improved. The house emerged stronger, cleaner, and more secure than before. The homeowner declined interviews. There was no desire for notoriety. Justice had been served, and that was enough. Still, the story lived on in the neighborhood, passed along as a cautionary tale about entitlement and consequences. HOA meetings changed tone. Members asked more questions. Votes were recorded meticulously. Contractors were vetted carefully. The culture shifted, not overnight, but permanently. Authority was no longer assumed. It was examined. Karen attempted to save face. She appealed informally, complained publicly, and hinted at further action, but nothing came of it. The judgment stood. The evidence was immutable. Eventually, she sold her home and moved away, leaving behind a reputation she could not outrun. For the homeowner, life returned to routine. Mornings were quiet again. The porch regained its calm. The sound of trucks passing by no longer triggered unease. There was satisfaction not in victory, but in resolution. The lesson lingered. Power without accountability is fragile. Assumptions crumble under scrutiny. And when someone causes damage believing position will protect them, the law has a way of reminding them otherwise. The house stood firm. So did the truth.